With apprehensions at the southern border at an all-time high of 2.4 million in the past year, the Supreme Court today took up a challenge to the Department of Homeland Security's enforcement policies.
At issue whether states have any say in the matter, Cronkite News reporter John Brown has the story from our Washington bureau.
In more than 2 hours of arguments over the Biden administration's immigration enforcement priorities this morning, the Supreme Court asked, when does shall mean shall? To the state of Texas and to some justices, the answer is obvious. The law says undocumented immigrants shall be deported and immigration officers don't have discretion in the matter. But United States Solicitor General Elizabeth Prologar argued that the government simply does not have the resources to deport all 11 million migrants in this country.
There are non-citizens out there who have criminal convictions for serious offenses like murder and sex offenses that wouldn't qualify under a shall because of the court's categorical approach. And that means we wouldn't have the resources or ability to go after those individuals who are threats to public safety, national security, and border security.
She was defending the Homeland Security Department's policy of prosecutorial discretion, which directs officers to focus on apprehending criminals. That policy was successfully challenged by Texas, whose Solicitor General, Judd Stone, argued that states bear many of the consequences of federal immigration decisions.
The states do not claim the petitioners must remove anyone in particular. Rather, petitioners' detention obligations arise before and after their decision to prosecute and run only to a small subset of this nation's illegal aliens.
But Prologar and several of the justices said Texas was on shaky ground with its claim that it could sue the federal government over supposed damages that result from the department policy.
First, the states lack standing. They argue states can challenge any federal policy that imposes even $1 of indirect harms on their own taxing or spending.
She said that allowing states to challenge and courts to vacate such policies sets bad precedent, a point echoed by Justice Elena Kagan, who said allowing states to block such rules essentially gives them control over federal policy.
We're just going to be in a situation where every administration is confronted by suits by states that can, bring a policy to a dead halt, to a dead stop, by just showing $1's worth of costs.
While the court considers the case, the administration's policy of prosecutorial discretion will remain on hold. At the Supreme Court, John Brown, Cronkite News.